Welcome to another episode on the Law Rapport. This is episode 70, and today we are going to deal with the amendments to the Police Force Ordinance, the Police Force Ordinance Amendment 2022-21 of 2022. This amendment deals with the powers of the police to conduct searches of persons before and after the commission of a crime anywhere in the Turks and Caicos Islands. The powers of the police to search motor vehicles. The powers of the police to erect barriers or roadblocks, and the duty of the police to make and keep a record of such searches. I'll be back to discuss these issues shortly, but before I do, my usual disclaimer. This is not legal advice, should not be construed as legal advice. For legal advice, please contact an attorney of your choice. Welcome back. So the amendment that I am referring to, as mentioned, came into effect on the 7th of November 2022, and this amendment was among a raft of amendments implemented in the Turks and Caicos Islands in 2022 in wake of the spike in crime and violence, especially gun-related crimes in the Turks and Caicos Islands. Now, Section 36A of the amendment was inserted into the Police Force Ordinance. Section 36A deals with powers of the police to stop and search in anticipation of or after violence. So, if there's an anticipation that there may be violence, the police, by virtue of this amendment, now have the powers to stop and search persons, and they have the same powers to do that after violence has been committed in the Turks and Caicos Islands. And this power to stop and search in anticipation, whether it's after or before violence, is not premise and reasonable suspicion, but it is done on the authority of the Commissioner of Police if he grants what is called in the ordinance at Section 36A, Section 1, subsection A, an authorization. So if he grants this authorization because there are serious incidents of violence in the Turks and Caicos Islands, or if there's an anticipation of serious incidents of violence, then the ordinance empowers him to grant the authorization to his officers. And as a result of that authorization, they can stop anyone in the Turks and Caicos Islands and search them for weapons. This authorization in the first instance under section 36A, section 1, subsection C, lasts for a period of 24 hours. But the commissioner, by virtue of section 2, is empowered to extend that authorization for further 24 hours. So this section confers on police officers the power to stop any pedestrian and search him or anything carried by him for any offensive weapon. To stop any vehicle and search the vehicle, the driver of the vehicle, the passenger in the vehicle, or anything in the vehicle, or anything carried by the driver or passenger for any offensive weapon. Again, let me repeat, this is absent reasonable suspicion. A police officer exercising the powers conferred by this section may not require a person to remove any clothing in public except for headgear, footwear, an outer jacket, a jacket, or gloves. So the officer could ask the person subject to the search to remove a hat, for example, or his shoes, or an outer coat, or a jacket, or a gloves. Police officer proposing to search a person or a vehicle by virtue of this section may detain that person or the vehicle for such a time as is reasonably required to permit the search to be carried out at or near the place where the person or vehicle is stopped. And the question of what is reasonable in due course, I believe, will be determined by the court. A person who fails to stop or to stop a vehicle when required to do so by a police officer in exercise of his powers under this section commits an offense and is liable on summary conviction to imprisonment for a term of 6 months or to a fine of $5,000 or both. So once there is an authorization in effect granted by the Commissioner of Police, and an officer initiates a stop, and a person or if he fails to stop or to stop the vehicle he or she is driving, that person commits an offense. The question would naturally arise, how would that person know that there is such an order in effect, and how would that person know that the police is acting in accordance to this section? Those are matters, in my respectful submission, that in the near future would be adjudicated in the courts. Section 36B grants the power to police officers to stop and search persons and vehicles, etc., on reasonable grounds. This is standard law. This is an import from the common law, where a person could only be stopped and searched if there is a reasonable ground to suspect that they have committed an offense, they are in the process of committing an offense, or they are about to commit an offense. However, this section goes, in my respectful submission, or in my respectful view, beyond the common law position. So, section 36B, section 1, subsection A, states, a police officer may exercise any power conferred by this section in any place to which at the time when he proposed to exercise the power, the public or any section of the public has access and payment, or by virtue of express or implied permission, or in any place to which people have ready access at the time when he proposes to exercise the power, but which is not a dwelling. And this is simply to confer the power, in my view, on police officers to search people in dance halls and discos and bars, etc. That is my view. Subsection 2 grants the power to police officers to search vehicles or persons for stolen or prohibited articles. And section 2, subsection B, grants them the power to detain a person or vehicle for the purpose of such search. So if they're acting under this section on reasonable grounds to conduct the search, they may detain a person, but only for the purpose of the search. Subsection 3 states that this section does not give a police officer power to search a person or vehicle or anything in or on a vehicle unless he has a reasonable grounds for suspecting that he will find stolen or prohibited articles. Over time, there have been numerous case laws on what constitutes reasonable grounds. So this is not anything that is novel. This is a well-trodden path in the judicial sphere, and I do not anticipate any controversy where this section is concerned. It's either the police objectively have reasonable grounds to conduct a search or not. Section 4 of subsection 4 of section 36B states that if a person is in a garden or a yard occupied with and used for the purposes of a dwelling, or on land so occupied and used, a police officer may not search him in the exercise of the power conferred by this section unless the police officer has reasonable grounds for believing that the person does not reside in the dwelling, and B, that the person is not in the place in question with the express or implied permission of a person who resides in the dwelling. So, in other words, a person in his own land that is used for dwelling, in his own private property, is exempt from being searched by a police officer absent of reasonable grounds. But if the police has reasonable grounds for believing that the person does not reside at that dwelling, or the person is at that dwelling but does not have the implied or express permission of anyone residing there, then the police could search. So for example, if someone is trying to evade the police and they hide out on property, someone's private property, without that person express or implied permission, the police, in my view, according to the legislation, would have the powers to search that person once he believes reasonably that that person does not reside at those premises. Subsection 5 also grants the police the powers upon reasonable grounds to search a vehicle or anything in the vehicle once the police officer believes that the person in charge of that vehicle does not reside in that dwelling or in that premises, or that the vehicle is in that place without the express or implied permission of a person who resides in the dwelling. So the police then, in my respectful view, could search a vehicle if that vehicle is in a place on premises and the person who is in charge of that vehicle does not reside at those premises, or if the person who is in charge of the vehicle has no express or implied permission of the person or of a person who resides at that dwelling. Now, this amendment also places a duty on the police to make records concerning searches. So, Section 36D places an obligation, well, a duty on the police to make a record of searches conducted. The record of the search shall be recorded in the police officer's notebook. Same for the search of any vehicle. The notes shall state the object of the search, the grounds for making the search, the date and time when it was made, the place where it was made, and whether anything was found. Whether, as a result, anyone was injured, any property was damaged, etc. Section 36E gives the police the powers to erect barriers or roadblocks. Section 44 of the Police Force Ordinance have already granted the same powers to the police officers, and the only changes that I can see is an increase in the fine. So under the section 44, the person who commits an offense under the section, upon summary conviction, they were liable to be imprisoned for a term of 6 months or to a fine of $100 or both. Under this section, the term of imprisonment remains 6 months, but the fine is increased to $5,000 or both. So this is some serious development in the law that the public ought to be aware of. And as often said, ignorance is no excuse to the law. When laws such as these come into effect and the public is ignorant as to the scope and effect of these laws, innocent persons can inadvertently be swept up and be convicted because they're not aware of changes to the law. Here is where I will leave it for today. If you gain anything useful from this discussion, please like, share, comment. But most of all, I thank you for taking the time out to look at this video. Bye for now. See you in episode 71.
Thank you for watching another video on the law report. Please like, share, comment, and most of all, thank you for taking the time out to watch this video. See you in another episode.